All right, guys, let's get started. I don't want to cut into any more time because I know there's lots of questions that we have today. I'm really excited to have our special guest today, Judge Aceto. I've litigated before Judge Aceto. In fact, right when I got out of law school, one of my very first oral arguments was in front of Judge Aceto, and he helped. I was just talking to Judge Aceto about it, walking over here. His memory is vague, but I remember crystal clear as day because it was my first argument, and I was already scared as it is. So I have a little. Anyways, Judge Aceto is now retired from the bench. She's been doing private mediation, which is great. We're going to talk a little bit about that. But Judge Aceto is always a very well-respected judge among the legal community. Ask any attorney in the HOA industry out there that's been around for more than 5 years, and they all know who he is, what he does, and several of us use him for mediation services. So thank you for taking the time to come address some of our questions. We, as you know, get lots of questions. We always want to figure out what's going on in the judicial, what a judge sometimes thinks when they hear arguments on the bench, when they see our cases. So we're going to get into that. Before we do, as you know, I like to start with dumb laws. Darwin was the first one here today, so he selected Nevada as our dumb law state today. As reading through these, there's some funny ones. In Nevada, it's illegal to drive a camel on the highway. So I don't know if they mean drive a camel as in sit on it and drive it, or drive it with a whip. I don't know, but it's still illegal. They're really serious about shooting dogs in Nevada. It's legal to hang someone for shooting your dog if the dog is on your property. So, don't hang anymore.
Don't shoot any dog. For sure.
What? What did you say?
So there surely wouldn't be any repercussions for that action, would there?
Yeah, no. Don't hang anyone.
No.
Please leave that up to law enforcement. Clark County, an ordinance makes bringing a concealable firearm into the county illegal unless it's registered with the Las Vegas Metropolitan Police Department. I don't know why that's a dumb law. That's a good law, actually. Oh, here's a good one. Elko. Does anyone know where Elko is?
Yeah.
It's in the middle of nowhere. Y'all know, who here's going to the Storm Area 51 event? No one? Really? I am. I don't know what you're talking about. I'm excited. I'm going to go finally figure out what's going on in the world. In Elko, everyone walking the streets is required to wear a mask. Apparently Elko has a lot of ugly people. All right. Nevada wasn't as funny as I thought it would be.
Good point.
There are some other states that are hilarious. Alabama, Texas had some hilarious ones. All right, we'll stop there. So anyways, thank you for coming. Just by a show of hands, how many of you had a question you submitted to us? I know there's several of you. So we were going to do it one of two ways, and I think, if you're okay with it, I'd like to have you ask your question. And when we're discussing these questions, some of them, I was talking to Judge Aceto earlier, and some of them, since he's been off the bench, the law's changed a little bit. So he may want me to clarify what the current laws are, and then to just give you his perspective as a judge would think. I know from here there's questions about attorney fees, why we're not awarding all attorney, why don't the judges award all attorney fees? What do you do if somebody is emailing you consistently and constantly, you're trying to get them to stop, and what a judge thinks about how you can stop a disgruntled or harassing homeowner. Those are a couple things, but I guess, Vicki, your question was right here. This one had to do with, go ahead, ask your question.
You know what, it was so long ago, was it proof of service?
It's the proof of service question, yeah.
How often do you deny proof of service, and what do you consider proof of service when you're trying to notify someone?
So let me make sure the question's clear, because proof of service in the legal community means a process server serves you. I think your question was more of, okay, we get to court to sue because somebody's not paying their dues,
And they say
I never received a letter from you. And so the question is, you've mailed a bunch of letters, you have the letters, you've got the addresses. Does the judge feel like that's sufficient to prove that they received it, like the mailbox bill, I guess, let's say?
So, I will say one thing to start with. Civil judges in Maricopa County handle a bunch of different things. We handle personal injury cases, we handle commercial disputes, we handle collection cases. And I can't say that any of us are experts in the statutory law that relates to what you folks do in your everyday work. And the way it works generally, but especially on the civil bench, is before I have to answer a question, I get pleadings. I get pleadings from the plaintiff's lawyer, then I get, hopefully if there is a lawyer, I get pleadings from the defense lawyer, and they clue me into what the law is. Then I get to cheat. I get to go read the law, which is what they really want me to do, and then I get to decide. So frankly, I don't know what the substantive law is with respect to that, but my gut reaction is, if somebody has an address of record that they've provided to you, and you mail to that address of record, that's probably good enough, especially if the person has been seen around the community. You could always try registered mail return receipt requested too, but.
We did that in this case, but the one I'm thinking of, but they, supposedly the mail people said they didn't have it. So we showed them that we had sent it out, but we never got it back. So we
Yeah.
always send it regular mail, and then we send it return receipt requested, so.
So on that point, the law, as most of you know, changed this year, where before you forward, and this is another question for you, is what do you think about this new law? The law changed to where before you can send an account to an attorney for collections, you have to send a final letter that has a statutory disclaimer on it that says that it's going to be forwarded to an attorney or third-party collection agency. It's all caps bold. And it says if you don't respond within the next 30 days, this matter will be forwarded to an attorney or third-party collection agency, and their activity may include foreclosure. And it also requires it be sent via certified mail return receipt. That's the first part of that law change. And the second part is that before you even reach that point, you have to send a statement of account to them via regular mail every time assessments become due. So almost like a mini ledger of the immediately preceding history, so they can see a breakdown of what their running balance is. And you have, like, so if they have monthly statements, you have to send that statement of account to them every month. So question here, one of you asked, what does the judge think about that new law?
Well, so I'm not looking at it from your perspective, right? Because I've never walked a mile in your shoes. And it sounds like that it's gonna be a pain to comply with the law. But if you're working with a good law officer, even if you're not, you can figure out a system on how to deal with that. And I think that would make many judges more comfortable when it comes time to dropping the hammer on foreclosure. Somebody's behind, less than $2,000, and you're gonna foreclose. It's not comfortable for the judge. So some judges will just go ahead and say, that's my job. Some other judges will try to, from your perspective, weasel out of it. I think there might be less of an inclination to weasel out of it now that there's all these notice requirements. So that's my reaction as a judge, not as a property manager.
Does the judge in that particular situation, when you say start a foreclosure, are they looking at how long they haven't been paying, or are they looking at the dollar amount? Say that you have a community that their assessments are $25 a month. You know what I mean? It would, and they've never made a payment in 5 years. But they owe, minimal amount. It's not versus like a condo that has assessments that are $300 a month and get out of control in 2 seconds. When you have a community where somebody's just living there and just not contributing to the community, it's just an overall difficult situation, I mean, do they look at the long, you know, they've never paid assessments in 5 years, or are they looking at, oh, they owe $3,000 or $4,000?
So I'm gonna look to Clint for a second. I don't even remember what the legal requirements are. It strikes me that there's literally no discretion for the judge. If the lawyer jumps through all the hoops, it's a yes or no, and there's no discretion for the judge. So what I'm taking you to ask me is the reluctance that I talked about a few moments before to try to weasel out or
Add a
find
dollar
a way
amount.
around it. Does the dollar amount make a difference? I mean, I'm trying to think back to situations where I have. It would get my attention if it was a relatively short amount of time, or if it was a relatively short dollar amount. But I learned after a couple of years in the job that I'm not God. And it's my job to follow the law. And if I'm being selfish, it makes more headaches for me if I start weaseling and not following the law. So personally, you know, it might give me hesitance. I might try to delay things. I might try to do whatever I could to get the homeowner in so I could look him in the eye and say, look, this is what's gonna happen. So yeah, the longer it is, the more that's owed.
I have a question on more of that, because a lot of times in a foreclosure for back assessments, they are also delinquent for violations, injunctive relief, just a problem property for maintenance. Do you also take in account what their property conditions are and any kind of judgments or any kind of current actions on that as well? As,
Well, the statute says we can't foreclose on fines.
sure, I know
Or
that.
the attorney fees on
But is
that.
it part of, like, hey, we're submitting it this for assessments, and by the way, we also have this in conjunction, you know, I don't know if that's gonna, I don't know if you can weigh on that, or is it something that would be a part of?
Well, can you speak to this a little bit? Because what I've noticed consistently is when judges look at a smaller amount of assessments that we're foreclosing on, and assuming we've met all the statutory requirements to get it there, to your point, if it's only $25 a month and we have a statute of limitations, as you know, the statute of limitations for foreclosure just changed from 3 years to 6 years. But when Judge Aceto was on the bench and all the other judges, it was 3 years. So we're bringing a foreclosure action because we have to within 3 years. The amount's small. Some judges balk that a little bit. I've seen traditionally that those judges will not award the association all of the attorney fees that were incurred, kind of as the way, like you mentioned, to weasel out of it a little bit. And you're smiling, so that was actually another question, and I think that will help answer a portion of your question, because that's what a judge, in my mind, and what I've seen does to help send a message to the association that not all things should be brought in front of them, I guess.
Cut your losses.
So, because you do have factors you can consider in awarding attorney fees, correct? And one of the questions is what are those factors?
I would pull out the associated indemnity case, and I can read them to you. And frankly, the factors don't really drive it. It's your gut that drives it, and then you have to make sure that you justify it.
Isn't that interesting? It's the attorney's gut that drives the attorney fees.
Yeah.
So can the attorney comply with the judge then, so we don't have to pay it?
Funny.
It was worth a try.
So I'll come back to the factors when I find them. But fact finders, whether it be a judge or whether it be a jury, look at stuff just like you do when you're dealing with people in your community. It depends what the frame is. How you react depends what the frame is. So non-payment, non-compliance, violations in other contexts they're irrelevant in a sense to whether or not there can be a foreclosure. But when the lawyer is painting the story, if he can find a way to paint a story to say, this person has been non-compliant in all these areas, they're a bad actor, he would use those words, but, and here's what we're dealing with now. I think to the extent that the lawyer is comfortable in framing the issue that way for the judge quickly, I think it is helpful in getting the judge on their side. It's, you look, you know, you have somebody who's never been a problem before and something goes wrong and they come back to you and they're apologetic. And then you say, but you blew up the laundry room or whatever it is. You're gonna look at it different than the person who's a problem at least once a month. It's just the way people look at stuff, I think.
So I have a question, I want to piggyback on that. So when you said that you would delay the case so that the homeowner has an additional time to show up and respond, that action there is costing the association more money because now the attorney has to come back and continue to work the case. And then when they do, then you cut the attorney's fees. So that's kind of it's a lose-lose for the association to even attempt to collect what is owed to them.
Yeah, that was a big question that I've been hearing repeatedly, and we talked about this briefly on the phone yesterday, and that is, if the judge cuts attorney fees, then the people that pay their dues consistently are the ones that have to eat them.
Right.
And then the board has to account to those homeowners at the next board meeting.
Right.
And so we were wondering from a judge's perspective, if you ever even thought about that process, or was it more of the factors of like, okay, this individual, the defendant doesn't have a lot of money, so if I award them all the attorney fees, she may go bankrupt, so I'd rather give them some rather than none, or she's, I don't know, whatever, just whatever your gut feeling is.
Have I ever thought about it?
Like, for
Yes.
example, if you're on the bench right now, and I'm arguing, Your Honor, if you cut these fees, the homeowners that are the good paying folks are going to have to eat them. It's rob Peter to pay Paul scenario, where this individual is the one that caused them. And by cutting the fees, you're punishing the homeowners. What would your response be to that?
It wouldn't be a controlling factor, but it would be reality that I think that I should be aware of before I want to be some sort of white knight to protect the homeowner. So I think it's a good argument, but I don't think that it's King's X that somebody's going to say, oh, okay. What I think of yesterday when I was thinking of these cases, I think of the reaction of some judges as this being sort of like a David and Goliath kind of a situation, and you're not David in this situation. I can remember my first couple of years on the bench when I would get HOA cases. They're totally different than other kinds of cases. Other kinds of cases get filed and sit for 18 months without anything happening other than me signing the scheduling order. Most of your cases are the opposite. They come in with a request for order to show cause right up front. I've got to get involved, I've got to bring somebody in. And when you're looking at, I'm not saying that this is right, but you're looking at your $2 million lawsuit and your David, what looks like to some people, Goliath is taking advantage of David over $750. You can go down the wrong track. So some of the judges that you see that you hate to be in front of, that might be part of the thought process that gets them to go down the wrong track. And I don't know of anybody on the bench. When I was on the bench, there were a couple real estate lawyers, but I don't know of anybody on the bench who had a lot of HOA experience to actually understand this the way that Clint does or the way that you folks does. So there's a lack of sophistication. There's this idea that you're often the bad guy and you have to do hard things. And then sometimes you see the HOA as a bully. I'm not saying that usually that's not legitimate, occasionally, I see HOAs or lawyers who are a little bullish. So then if you see that, that like fortifies, that idea. And we had a judge at Southeast, and he was a great judge. His name is David Talamonte. He's retired too now. And I think a lot of people in HOA cases noticed him. And so I think he probably had a soft heart, although I was never in there, but I think he had a soft heart in HOA cases. Or it could be Southeast is kind of there's only 3 judges out there, and if you notice one judge, you know who else you're gonna get. And you were gonna get me, or you were gonna get somebody called David Udall, who was better on these cases. So, you know, some people are good judges, but lack of experience, and for some reason, they relate to David in these cases, I think.
One of the things that we would try to do, and tell me if this would soften your heart, I think it probably did in some of the cases that I've seen, but we would come to the court if we've got an enforcement matter. And we could tell the judge in the return hearing, which is a couple weeks after we file, Your Honor, we've reached out to them, we've tried to offer mediation so that we could avoid the court, but they're continuing to build this, or paint their houses bright pink, or build this huge monstrosity, and all the neighbors are screaming about it, or you've got John that keeps drag racing down the street and creates all the noise and safety problems. We've tried by letters, we've tried by telephone calls, we've tried by mediation, and it's been quiet. Do you feel like that helps show that we're not being Goliath right up front, but we're more approaching this from a reasonable perspective, which would help your thoughts when it comes time for an award of attorney fees to award more because we are acting reasonably?
I was usually around 80–90% of the fees, no matter what, unless there was a reason not to, because I understood that was the rules of the game. That if you don't award fees, you're encouraging people to, and the defense lawyers to say, well, he's not gonna award fees, so we can jack everybody around. So, but yeah, that is good stuff. I've got a feeling that there's some judges that are almost always gonna be light in fees. But I would defer to you, because I'm not.
I see some judges just award 50% of the fees, just almost as a matter of course. I see other judges, like I know you were awarding between 80 to 90%. That was what your number was. And I've always told my clients, and correct me if I'm wrong, but I've always told my clients, I think judges do that because they know that if they reduce them a little bit, the chances of them being appealed is gonna be reduced significantly.
That's probably part of the habit. I mean, they didn't think about that. I only awarded 100% of fees one time. I can remember the
Ouch.
time that I awarded 100% of fees.
And why was that? Do you remember?
I saw everything play out in front of me. The fee sheet was on one page. It was a trial to the court. I saw absolutely everything. It was a stupid defense. It was a waste of everybody's time. So I just knew absolutely that was the right thing to do. So we're supposed to evaluate every entry on an attorney fee request. The rate is always good with HOA lawyers, right? There's no question about the rate. It's reasonable, but you wonder if there's a little bit of wasted time, or I've never found much. I don't know. That was my habit to start out around 80 or 90%, depending on the circumstances.
Thank you.
That's a good answer. Yeah.
Well, it's good to know that, to be able to
Yeah.
tell our boards that, hey, we're going into this.
You're not getting all your money.
Yeah, but at the same
See
time.
Ever.
Do you see anybody who awards 100% more than occasionally?
It happens more often in default than because the fees are low anyways, traditionally lower. In the last, I'd say, year or two of our cases, Ashley, Maura, you guys do a lot of the litigation. How about, do you see the southeast side cutting a lot of attorney fees? I don't. I do see the 80–90% rule is kind of what carries the day for a lot of folks.
I don't even know who's out there now.
I think in when we get default judgments, it's easier to award the fees because they just haven't participated at all in the litigation. So in those contexts, I think we get them just kind of signed off on more so than when it's a contested or an enforcement matter. But I just had a default hearing in Gila County, and I just got, our fees were a little bit on the high end because we did have some back and forth with the owner, and they awarded 100% of it, no questions asked, which I was surprised by, because I was thinking, Gila County, smaller county, they might think this is a little bit high for a Gila County attorney's fees request, but they gave us every penny.
Yeah.
So it really is hard to predict. I think it does have to do with the strength of the defense case, how much participation there is with the defendants, and how strong the association's case was, I think.
I know all of the attorneys are getting smashed right now, completely annihilated in Pima County. Foreclosure, the judges are awarding around $250 to $500 in attorney fees total, or $750. Wasn't that what it was?
Yeah, I think we got a $750 award to file a complaint and get a default
Yeah.
judgment, $750.
For us to go to foreclosure and do all of that paperwork and everything else, and also another judge was requiring us to produce receipts and proof that we actually worked on the matters in our fee affidavit, which strikes fear into the hearts of every attorney. But so I know that one of our attorney friends at another firm, HOA firm, is appealing right now what Pima County is doing to Division II Court of Appeals.
Mhm.
And we're hoping to have a ruling soon to get that stopped. Because I think, and I don't know, I can't put words in your mouth, but by the way you reacted, it sounded to me, or looked to me like you would think that would be crazy. $750 for a whole foreclosure.
Right, they're just, I
It's
don't
like
know.
an hour and a half.
I was sort of wondering what's happened down there. It's a smaller group of judges, and maybe they had a leader who said, hey, look, and behind closed doors, he or she convinced everybody of his or her perspective on it. Maybe you had somebody who was an HOA lawyer, who maybe represented homeowners in HOA cases and then became a judge. I don't know, but it's not just like one or two people, it's like, so they were in a meeting somewhere and they talked about it.
I would think so. My Uncle Sam is a justice court judge and in Santan. And he says they do those round table judge meetings and talk about what the judges are gonna award, and I think they came up with $500 or $750 at one point.
And the average is still like $4,500, right?
$450.
No, for a foreclosure.
Oh, and foreclosure is Superior Court, different courts, so yeah.
No, what, you're wondering what the
I
average
think the average
bill would be?
The average bill is about $4,500. If you go
Okay.
to most firms, some are a little higher, some are a little lower, but I'd say $4,500 in attorney fees is about what everybody's charging. Yep.
So, and when judges get together, it's with Superior Court judges, it'd be a little different than Justice Court judges, where you wouldn't, like, wink wink, say this is our policy, but you would talk about it. But it's a good thing in a sense that, like, when you're sentencing criminal defendants on felony cases, you don't want the sentence to so much depend on what judge you're in front of. So you can't guarantee uniformity, but it's a good thing for judges to talk so that they're at least close. But if they get together and they're making a mistake, it becomes a bad thing, right?
That was one of the questions that we saw in here, was somebody had asked, do judges get together to talk about these HOA cases? And when they do, does that impact their decision in a negative way or a positive way?
I never remember a judge's meeting, and I was the civil presiding judge for a couple of years. I never remember a judge's meeting where we talked about that. There could have been a question and then people bounced off of each other, but as opposed to trying to educate people on how they should handle them. I don't remember HOA cases.
Do judges talk in the cafeteria offline about cases? Hey, get this one, get this.
Oh, yeah. Just as much as lawyers talk about judges, judges talk about lawyers.
So that's an important question is, does your award of attorney fees sometime depend on whether you like the attorney or not?
So let me, first, I found the list of factors that the judge is supposed to consider in deciding whether to award fees, and if so, what amount of fees to award. And it's a pretty long list, so I'll try to shorten it. 1, whether the unsuccessful party's claim or defense was meritorious, which is a little weird, because if they're unsuccessful, it wasn't meritorious the way I used the word. But, whether the litigation could have been avoided or settled, and the successful party's efforts were completely superfluous in achieving the result. Whether assessing fees against the unsuccessful party would cause an extreme hardship. Whether the successful party prevailed with respect to all the relief requested. Whether the legal questions presented were novel. Whether the award would discourage other parties with tenable claims or defenses from litigating or defending legitimate issues. So that's a lot of legal mumbo jumbo, but that's what the case says. And what it boils down to is the judge has almost absolute discretion. I was wondering about the Pima County case, how they're ever gonna get the judge reversed on a discretionary call like that. But I guess the Court of Appeals also looks at things in a frame, and if they see a pattern, which is an illegitimate pattern, they might look to find a way to reverse.
Just seems if the Pima County folks know that going to Pima County, they're gonna eat almost everything to foreclose, they're not gonna wanna foreclose, and then you've got an owner living rent-free essentially for a very long time.
Right, it's not right.
Right.
It's not right.
But to go into that question, do you sometimes award attorney fees or make rulings based on how you feel about the attorney?
Absolutely not.
Good answer.
Maybe.
I can neither confirm nor deny that, I guess, right?
So the thought, the thought process real quick is, if I ever get it in my head that I don't like this guy or gal, and that's gonna impact on my decision consciously, I say, there is absolutely no way in the world that I'm gonna let that happen. But then maybe unconsciously or maybe even consciously, if I think somebody, this is a horrible thing, the way a former boss of mine used to use the phrase, it was even a little worse. If I think somebody's screwing the pooch, if I think somebody's milking the bill, that's a legitimate thing, right? And the idea that I'm supposed to forget about my experience with that person, and just judge based on the papers in this case, that's just unrealistic. We see lawyers over and over again, especially HOA lawyers, we learn about their reputation, have an impression about their reputation. So, for me personally, and I think for most judges, just because I don't like a person, am I gonna punish their client with my decision on fees? No. But if I think that they're a bad actor or they're milking it a little bit, yeah, maybe.
Do you ever pull them aside afterwards and tell them some of your reasons? I've never had that happen to me.
If I've had conversations with lawyers about fees, I don't remember them. But I mean, there's 3 big filers in Southeast, and of the 9.5 years I was on civil, like 7 of them were in Southeast. So there's 3 big filers, so I would see the same people over and over again. I would have conversations with them to the extent that I legitimately could. So, maybe. I mean, the 3 biggest filers in the state are in Southeast, I think.
Yeah. In case you're wondering what he means by Southeast, the Superior Court's broken up. Southeast District is at Avelina and Mesa Drive, which is right off of, 60. That's actually where we file. It is based on the office address of the law firm.
What can we do as an HOA or a company to help judges better understand what we do and why we take the steps that we do, and I mean, there's some way to have, you know, a round table with judges and kind of show them, you know, a standard policy in the industry on fines, or a standard policy for collections. I mean, generally speaking, I mean, this business is incestuous, so you've worked at a couple companies in your time, so you know how policies work. And I mean, if we can educate judges so that it's not just whatever's on the news, that the HOA is the bad guy versus slamming a big old sticker on your garage door. But, you know, I mean, it's just one of those things where you're asking an association to follow a contract that you signed, and then you're asked to enforce that contract. And then we often, in my experience, which in legal, we don't win. I mean, you still feel like you've lost, even if they rule on your behalf, should I say. You somehow still lose because it's not compliant. The HOA, you know, harassed them. It turns into a community fight over, you know, this, versus just making people understand that you signed that contract. You agreed to these rules and regulations. You agreed to these payments. And I just kind of feel like it's turned into a situation where our industry is, an HOA is just that. Don't buy an association. There's still places out there that you don't have to. But it's just, how do we become, I guess, in better light in people's eyes?
I think part of the problem is us. And let me explain that a little bit. Us meaning the attorneys. Let me explain why. I think we need to do a better job of explaining to our client base that when you follow a contract, absolutely, the judges for the most part will enforce those contractual provisions. I'm just saying this real quick, then you tag on, but follow the contractual provisions. But what we've done a bad job of doing is help manage expectations of the client, because attorneys do charge a lot for compelling compliance to that contract, whether it be collections or compliance, whatever. But what we haven't done is a good job of is explaining to the client that they probably aren't going to see everything back. Because you're talking about feeling like you lost. It's most times, 99 times out of 100, it's because you have to eat some attorney fees. Because we do get the ruling, but or it's either that or it's gone on forever and everyone's just battle worn with the litigation, or there is some attorney fees that have been cut. The issue here is I think a lot of the judges look at this as a corporation and a cost of doing business, and so they try to award as much as they can, but they also feel like the attorney, or whether it's an appeals decision to cut fees and not be appealed, or the attorney is charging too much, they need to cut some.
It's not just fees, it's the overall impression of the fact that HOAs are Goliath. You know, no, you agreed to be part of that. You're not David. You are part of Goliath in non-compliant. You know what I mean? Whether it be payment or violations. How do we get people or judges or as a whole to understand that it's an agreement? It's a binding contract when you closed on your home, and it seems like just, you know, newsbound next door. You know, things like that, that the HOA, no matter if it's right, wrong, or indifferent, is the bad guy, or ruling in favor of non-compliance of, you know, signs in their yards, or painting, or super garages, or parking in your yard. I mean, we're not winning these battles in a sense, because there's no way to enforce on the back end of it. A judge might rule on our favor. How do we enforce, and how do we not turn out to be the bad guy?
Well, part of it, well, let me go back half a step. The first thing is you talked about educating judges, and I think that's important. I think judges need to understand your perspective, and occasionally, if, for example, Clint knows a judge who might invite him to a meeting, maybe he can do a little bit of that. But it happens on a case-by-case basis. And, I mean, some HOAs do wacky things.
Some
And
do.
sometimes, you know, the board is in charge and the board makes it's to make decisions, and sometimes they're, probably more often than not, they're too lenient, but occasionally they're too harsh, and they're used to winning every time, and they're used to thinking they're gonna win every time. And if something is clear in the contract, you're pretty good. If something is an arguable interpretation of the contract that a judge perceives to be overstepping your bounds and pushing people around, they'll remember that. That's the one they'll remember. I think about juries, so this is probably not a direct example, but O.J. Simpson, if he were tried in Brentwood, he would have been convicted like that. He was tried in downtown LA, he's acquitted just like that. So the experience of the fact finder, whether it be a juror or a judge, makes a big difference. And if the judge had an experience, or somebody in his family had an experience with an HOA where they felt they were run roughshod over, or they were really run roughshod over, and that's in the judge's experience bank, that's a hard thing to overcome. So all you can do is your best. I think I read one of the factors, whether the litigation could have been avoided or settled. I think judges are never gonna wanna have the feeling that they just want you to go hell-bent on election and roll over somebody, not that you do that. But they don't wanna get that impression. They wanna get the impression that you've worked with people, and it's built one case at a time, I think. And occasionally we'll remember a particular HOA. And as a matter of fact, I think you were on this case. I don't know if my son-in-law talked to you, but he was at some condos he was renting. He was at some condos which are pretty close to Bank One Ballpark. And I said to him, I think it was, the requirement is you have to keep getting approval to be a rental. And I'd had a couple cases like that. And I said to him, you know, John, you have to remember. And then his father died, and he missed it. And so, yeah, I even said, I told you so.
Who'd you say, I told you so too? Oh.
To my son-in-law.
Yeah, to keep
Oh,
to
gotcha.
those. And I was on the case, but I'm not, I can't get into those details. Other than to say that, you know, the association's doing great.
Yeah, I wasn't saying that was an example of that either, because the association put it out there and people should have known, but it.
We tried our hardest to make sure that we didn't go to court until we'd done everything we could to get people on the same page. But like you mentioned, there are those circumstances where you have a family death or whatnot, and we have to make sure we play the mercy card in those situations and give them additional time, but not stick strictly to that enforcement policy and go right to the next letter. When you have those scenarios, that's a surefire way. Can you imagine me standing in front of Judge Aceto saying, Your Honor, I don't care that his father-in-law died. He didn't get approval for his rent. Why couldn't I have waited another 30, 40 days and worked with him a little more?
I think you do a good job of keeping us grounded. Because I come in pretty hot once in a while. And then you're like, no, and then it's reasonable, so.
How much is it driven by the board? I mean, you folks have different communities.
Constant.
Well, that depends, because it could be the board that's the problem.
Yeah.
I mean, in the sense like they're the one in violation.
Yeah, I think it's driven by all sorts of factors. We
Yes.
see boards, you all,
Right.
you all agreed some audibly on that.
There are some crazy ones out there.
Yes.
Yeah, but there are others that listen to you, and there are others that let you do your job.
Some of them just go, right? They just flow and it's just process,
Right.
and this is the way it happens.
If it was up to the managers to run the community, we wouldn't ever really, I don't think, have major issues, because every one of these managers are great. They're all licensed, they all keep up and with continuing education credits and get taught by attorneys and everything else. I think the management side of things is great, and sometimes when we get those crazy boards, some crazy boards, for the most part, most of them are great, right?
Right.
That's-
Right.
Here's a question, and I think right by a raise of hands, how many of you, and I wanted to ask you this, Judge, how many of you receive harassing emails from an owner in your community?
Not anymore.
Okay.
Not anymore.
So here's the
Yeah,
question
even
to
not
you.
anymore.
And this has been a topic of discussion that continues to become more and more popular because it happens more and more. There must be something in Arizona water where it just makes owners disgruntled. When you have a manager doing their job and they get very abusive emails from an owner, repetitive, using profanity, just abusive because, like, for example, the manager's caused a compliance letter to be sent out and it just spirals out of control for a very abusive, unreasonable person. One of the actions we take, if it becomes too abusive, is to go to court and ask the judge to order the person to stop harassing the manager. Do you find it reasonable to order an owner not to email a manager as an injunction?
So is this an injunction against harassment or injunction against workplace harassment?
Workplace. And do you guys know the difference between the
No.
two?
No.
Do you mind explaining the difference?
I'm gonna defer to you,
Okay.
I haven't done one in a long time.
So injunctions prohibiting workplace harassment is when the association's the plaintiff, because that's the entity. And the association's an entity, so instead of employees, members, it's just part of the workplace. And even though there's no paid people, an injunction prohibiting workplace harassment is the same tool as like a protection order if you were abused by if you have battered spouse syndrome, you go to the court and get an injunction prohibiting just harassment. It's the same thing. The difference is an injunction prohibiting harassment is a person, an individual. Let's say I'm spouse X and I want to get ex-spouse Y keep from stalking me. I can get that. Or threatening me or abusing me or whatever. Injunction prohibiting workplace harassment applies when an owner does essentially the same thing against the agents of the company.
I've had one.
Yeah, some of you have, I know, and I know we have several pending lawsuits like that. What is your take on those?
So I haven't done those in a really long time because it evolved where commissioners would take those rather than judges. But my gut reaction, and this is a gut reaction, not something based on experience on the benches, A, absolutely it should be stopped, but B, it seems like it's a little tricky because you need some sort of communication to be able to go forward without being a violation of a court order, so that's what pops into my
We
head.
have to give you an out, right? And that out maybe, if we said, okay, order them to stop communicating via email, verbal onslaught to the manager, but submit in writing to us or email the attorneys. Is that something you'd say, yeah, no problem, do it?
Makes sense to me, yeah. And you have the copies of the emails that you would show, so that it's not a he said, she said, it's in black and white. So, yeah, that makes perfect sense to me. Speaking of that, somebody asked a question, do pictures help? Oh, yeah. If it's a good picture, that shows exactly what's going on, absolutely. This idea that judges are like human lie detectors, I can look at somebody, I can't tell whether they're telling the truth. I get story that it's black, I get story that it's white, and those are real quandaries for a judge. What do I do? Who's right? How can you tell? But if there's a picture, you go ahead, you can argue until you're blue in the face, but I got the picture right here. So I don't know if that's helpful, but that from a judge's perspective, we want something that's clear. And pictures, a good picture can sometimes be very clear.
Picture speaks 1,000 words, in other words. So going on that point, let's say you have this very clear picture of a violation. You've already ordered the individual to cure the violation, and they don't do it. This goes to the issue that the association still feels like they're losing because a judge has entered the order to demand the individual cure the violation, and they still ignore the judge's order. And the next step is for us to come to you and ask that they be held in contempt. When we ask you to hold them in contempt, what do you consider in that? And what are some of the sanctions you had and a judge has to compel the individual to cure the violation.
I don't think I ever put anybody in jail for a homeowners association violation. But I mean, that's the end of the row. If somebody keeps coming back on contempt and there's proof that they haven't been complying, that's possible.
So jail is the end of the line, what's in between?
Don't they have self-help?
Fines?
You could do a monetary sanction for civil contempt. What else could I do?
Awarding the rest of
I
the
would-
attorney's fees.
I
already lost on that one.
If somebody's really violating, I'd be happy to award 100% of the attorney fees on that, right?
Yeah, so what I've done is sometimes I'll go in and I'll say, look, Your Honor, give us 100% of our attorney fees to come back on contempt. If the judge finds their contempt, yeah, they do award us the 100% at that point. It's
Even
a
the back
sanction.
ones that they didn't.
They
award?
haven't yet, but one time I went in and said, Your Honor, look, there was some significant attorney fees waived. We're gonna request that you award all of our attorney fees and a $20,000 monetary sanction, just as a penalty, if they don't cure within 30 days. So they still have an out of 30 days or 60 days, but if they don't cure it, and that was like the second time we had to come back for contempt, because the judge had already found it in contempt, and they still didn't comply, we'd already gotten our attorney fees award on that one. The second time, the judge is much more open to us, like you said, it's like that,
Yeah.
the progression. So the second time we asked for $20,000, she didn't cure it, so the $20,000 went in and we recorded that judgment lien. The third time comes
Ouch.
around.
She'll feel that one.
Yeah, I think so.
That's if they pay it.
Right.
Because
Well,
then the
well,
problem
when they-
is
when they
us
sell their
forcing.
house-
When they
sell
sell
their
their
house.
house.
When they
their
sell the
house.
house, if they sell it.
But they could sit on it forever, or they could pay it and then get on the board and pay
So-
themselves back.
So that's the thing, Judge, you said outs, they'll fill that one.
Sure.
Well, they try to come up with creative things, but still, the outstanding issue is the violation still hasn't been cured. By that time, the board is getting weary. So I'm coming back to you for a third time. The 20,000 monetary sanction over a year has passed, has not worked.
Just a judgment.
And
It's
now
just a
I'm gonna
judgment
ask
and
you-
the person is still resisting.
So the judgment, you found them in contempt, you awarded all attorney fees, that was a year and a half ago. 8 months ago, you awarded all my attorney fees on a second contempt hearing and ordered the $20,000 sanction I was just talking about. I'm back in front of you 8 months later, saying that there's really no equity in the property, so they don't even look at this as a penalty. Our next request is, put them in jail. Or sometimes, I heard is self-help. Some judges, like, I know Judge Talmonte loved that one,
Yeah.
where the judge gives us the self-help right as a contempt power to go in with law enforcement and detain them if necessary, and then go ahead and do it and charge that back to them as a foreclosable assessment lien. And if they don't pay it then, we can just foreclose, because it's not a judgment lien that we can't foreclose on because of the homestead exemption. And that's been the next one. But the association at that point, that's what I think I think most judges don't have a problem with that. But the problem I have with that one is sometimes the association can't afford a $30,000 cure job or more. Like, let's say it's a huge gazebo and that everyone's complaining about in the neighborhood, and it's gonna cost 80 grand to do it. And the association's not gonna come up with 80 grand to do it. So what, I come back to you and say, hey, Your Honor, we can't do the self-help, that's not an option.
I would be frustrated if you asked me to do the self-help and then you realized after the fact that you couldn't do the self-help. I would-
Well, you bring it up and I say it's not an option for
Oh,
those
okay.
reasons.
Okay,
And now I just.
especially in a smaller size HOA, right?
Yeah, exactly. Like a 100-unit community, dues are $25 a month. 80,000 represents,
Huge
the whole
numbers.
pavement of the street job next year goes away because of this.
Yeah.
So I explained that. We both understand it's not gonna work. Now what are you thinking?
Boy, I'm threatening jail, but I'm very reluctant to do jail right. But I'm threatening it, I think, at that point. I mean, this is a long road to get to that.
Yeah, exactly.
Yeah.
This is
A lot of
nowhere near
attorney's
early
fees.
on.
And-
But if
and I-
I'm at the end, if I'm
Well, how
at
broke
the
is
end.
the association from the attorney's fees trying to get
Right.
there? And
Right.
it's not, and it's nothing against what they charge. They they have a profession, they have a reason, they have an education to do this, and that's why we need them. It's not that we're arguing that they overcharge. I'm not, because then we would just change attorneys, encourage the board, hey, I think this one's inflating, we've got 15 other attorneys we can go to. So
You don't wanna
that's-
change this attorney if he's your attorney.
No, but, and I don't disagree, I mean, I've worked with him in the past and I've been happy, but, I mean, again, there are other good attorneys out there, so I'm not saying anything, bad about, other companies that I've worked with. I'm just saying that, we have a choice to change attorneys, so it's not about the fees, it's about understanding compliance and having a resolve, and I just kind of feel like the way that society's moving and the way that courts are moving is we don't have an out and we don't have a resolve. We can't honor the other, 199 homeowners that the number 200 is not doing the right thing. We're not getting what we need out of it in most cases is the way that I feel in experience. And I don't know how to explain it. It's not just one association, which they're gone. But it's multiple situations throughout the years, because I've been doing it a long time. It seems like it's getting worse, not
So
better.
to piggyback on that, let me give you an outside the box suggestion. You've never heard of this suggestion before. I've never requested it of a judge. I just wanna know whether you give it to me. That same scenario, you're giving them stern warnings on the bench that look, I'm seriously considering jail time now. And I come to you, we've already concluded self-help's not really the best option. I ask you, Your Honor, as a sanction for contempt, give us the authority to just tow their vehicles anytime they park in the community and trespass them from the common elements, common areas. Would you, as a sanction for contempt, consider allowing us just to tow their vehicles off of common area? And trespass
Boy,
them from all
It
common
feels really
areas?
funny. I'd have to be sure that it would work. The trespassing off of common area feels a little more comfortable for me. than
Not
towing the
enforceable.
vehicle.
And give us the
Yeah.
right for law
Easier to
enforcement to
storm
arrest
jail.
if they do
Right.
go on the
Right.
common area?
Well, if I was gonna do it, I would do in my minute entry, I would do a specific thing that you would just be able to hand to the police officer, if the issue came up, right? And you'd be taking pictures of the person when they were there
Yeah,
because
so
then
that
they'd
could
run
be
away and say, I was never there.
videotape of them trying to use the common area laundry room, the common area pool.
Don't forget the mailbox.
Man,
Well, the pool,
why-
the pool
I'm not
sounds
mentioning your
easier.
case.
The pool sounds easier. The pool sounds easier. But so one thing that happens with judges, if they're smart, is they've gotta protect their time. So if somebody keeps coming back, and I know that the homeowner, it's all their fault, I'm not on your side, but I'm on your side. I'm trying to get it over with. I'm trying to figure out a way to get it over with so that you don't keep getting abused and my time doesn't.
Yeah.
And on
keep
top
going
of
up.
all that, they get big bucks. We're over here going, God, I'm not getting paid anymore for this. And it's taking a lot of time.
I think I'm gonna
It's
try that.
frustrating the board.
I think I'm gonna try that route. I'm gonna try the trespass route and see what the judge says. I'm gonna try that. If I've got a client willing to try it.
I just was curious, has any judge thrown an HOA violation, a person in jail?
I
Did you
don't
know?
know, I don't know one.
That would have
I've
made the
never seen
news.
one.
I
I've
know.
seen, up in
We would have known
Yavapai
that.
County, I
And
had
they're
a
wearing a
case that
flag
went
shirt
on
while they arrested
forever.
them, so now we're not.
And the judge got to the point, because he'd already threatened jail, we were there for the 4th hearing on contempt, and the judge looked at him and said, okay, if the violation is not cured in 60 days, jail time. Because in that community, it was on a hillside, and the cabin was structurally unsound to the point where it could impact the entire road that all of the members above it could access. So the judge was inclined, because of the gravity of the violation, the judge was actually going to put him in jail. And it got resolved at that point.
It's a lot easier than the wrong tree. This tree isn't on the approved list.
Yeah, and it is the violation. You're right, Judge. I would never get somebody in jail for a tree or parking or a,
Yeah, we came close with Bob.
yeah. Any other questions before we wrap up,
I have
folks?
one. For annual meetings, for quorum requirements, that you tried to get quorum for both of the homeowners associations, and it doesn't have a reduction provision in the bylaws. And you just kind of like keep trying till you keep trying. And obviously, you can't make quorum to even get the CCNRs changed, which is a higher quorum than changing.
Right.
So what, do we come to you and go, I need a ruling to actually change this?
I'm gonna defer to you, but I don't think I have the power to change the contract.
Oh, darn it.
No, we'd have to get a receiver appointed. We'd ask the court first for a receiver with plenary power of the court, and the receiver has the authority to go in and change your documents. But in that scenario, this Nonprofit Corporation Act already addresses what you do. The board continues to act as the board as an interim board
Sure.
until they're replaced after
Sure.
quorum is reached.
But
But
they've
what if
never.
other homeowners want to engage? I mean.
The problem I have when this comes up is when you've got a community that now is in dire straits because they don't even have a functioning board for so long.
Yes,
That's when we have to start talking about a receiver being appointed.
right. And
Because,
recall the board because they have
Yeah.
controlling.
and then what I found, I've never actually had to get a receiver appointed yet. You know why? Because when everyone finds out how much it's gonna cost them for a receiver, and when everyone finds out that the receiver can just take the documents and throw them in the trash can until the community's back on the feet, meaning they just especially, I mean, receivers are like us, right? We're the attorneys, we charge our rate to operate the community. And when I look at a community, if they're completely upside down on their finances, if I'm the receiver, appointed by the court, I may just special assess everyone $15,000. Whatever I feel like. And when members find that out, you better bet there's gonna be quorum for a meeting coming up in a couple of weeks. So if you're in that scenario, threaten receivership, and I'm not lying about that. That is the heaven's honest truth, and that is receivers do have that power in that scenario, and that will help people get off their
But
couch.
you've never done a receiver, like when the market fell out? I mean, there were multiple communities that.
I'm talking about like, well, I have never had to have a receiver come in and actually, me personally.
It's so ugly. The receiver's working for me. His bills are good. I've seen his bills. The receiver bills just,
Mhm.
they knock your socks off.
Wow.
And he's working for me, so I gotta make sure, at least I have the feeling that I gotta make sure he's getting paid. You don't wanna go there.
Why did you become a
Unless you
receiver?
have to.
The management company appoints them. I mean, the receiver, you hire them for that association when they don't have a board. I had it happen once, many years ago, and it only lasted like 30 days. But in that 30 days, the bills were pretty hefty, and the board engaged quick, or homeowners became part of the community quick and established a board that they didn't have a board.
We've threatened it many times, but ironically, everyone ponies up at that point. They get the vote through, whether it's for loan money from the bank to approve a special assessment, to increase their regular assessment way beyond the maximum annual assessment. And they approve it because they finally get the message. And I know of only 2 other firms that have been around a lot longer than us that have ever even done it a couple of times. All of you, there's only, so you mentioned one, but I don't think anyone else here has ever done a receiver or even heard of it. So, yeah. All right, well, we're at 1:15, winding down.
Really quick one about
Yeah.
the emotional support dogs. It's going on in a community, it's a condo community, they have a rule of a 20-pound limit for the dogs. And now there's a couple dogs that have come in and they're, getting violations, this is over the pet limit. And then they're coming up with this emotional support stuff. And then we've got a board member who's like, well, I moved here because I'm afraid of big dogs and I feel like my rights are being violated, so now I don't know how far this is gonna go.
That's a
'Cause it's like a
quagmire.
fair housing thing and not really sure. The board wants to deny the reasonable accommodation request from the two owners stating these are the emotional support pets. And, you know, they just recently moved in with these animals, and so.
When I think of reasonable accommodation, the word you used was quagmire instead. And I guess they know that that creates a quagmire, because it does.
How many fair housing cases in associations did you handle on the bench?
Not a bunch. I had one as an arbitrator not too long ago, and it was just a black hole. It just kept getting bigger and bigger and bigger and bigger.
One of the things, so just, I think your question is better answered offline.
Okay.
Because there's a lot, it depends on a lot of the facts and circumstances. But moving forward, I think one of the things we're trying to do, when I say we, our office is trying to do, is promote mediation more. There's a pro and there's a con to it. You have to have two parties to dance. Two have to tango. If the owner isn't willing to go to mediation before a lawsuit to resolve the problem, then there's no point in doing it, because it's a waste of money. But if you really have somebody that's willing to listen to a mediator that's got experience, Judge Aceto's great. He does wonderful mediation. I know, like I said, all the attorneys you work with, whether it's me or another firm, we know Judge Aceto. A lot of us are using Judge Aceto for, not Aceto, sorry, Aceto.
You say potato.
Potato. For private mediation. And so keep that in mind as you've got boards that have issues. If they feel like things can be mediated, Judge Aceto's great at it.
And sometimes it's in the documents that it's supposed to be mediated occasionally, but you're right, sometimes it's like you're banging your head against, you try it, and there's no way that the person can be convinced.
Like if I go to you in a return hearing after I filed an enforcement lawsuit, I say, Your Honor, we have tried mediation and it failed because they didn't even show up. We scheduled it, we tried it, they didn't show up. How much more willing are you, how much more do you think we're reasonable at that point than if we just came to court? Does that make sense?
Yeah, my gut tells me that you tried, you set it up, they didn't attend. That to the extent that the documents allow me to reach that conclusion, I would say, okay, we're done.
Hey, real quickly, are we suggesting that the managers approach the board and suggest mediation, or should we as the attorneys?
I think this is
recommend it?
both of us. It's kind of a group effort, right? I think if it makes sense and you don't want to spend 60 grand in litigation, and you do think that things can get resolved, if you just have a third party, a smart person there that's a judge that knows the drill,
What's the
go.
standard cost for a mediation? I have no clue at all. Sorry, I have to ask the question.
$350 an hour and
How much?
$350
Okay.
an hour, and it's probably at least an hour of prep and probably at least a couple hours for the mediation.
Got it.
Do you make the ruling at the time of the mediation, or I mean, not ruling, but I mean, is it considered a ruling, or how nothing?
Mediation is not, it's, you don't have, arbitration is where the arbitrator makes a ruling.
I think I had the two confused. in my mind.
Yeah,
Okay.
mediation is where the sole
Just come to
job
an
is to
agreement.
get the parties to settle. So I found that the judge comes in to your side, tells you everything wrong with your case, and goes to the other side, tells them everything wrong with their case, to soften them up, and then say, look, guys, let's settle. Because their sole job is to get the case settled.
But
Am I
once
wrong
the
on that?
people, once the
No,
parties,
you're right.
Huh.
once the parties agree though, then that's it, right? Like
That's
now.
binding agreement.
Yeah, okay, it's binding agreement, okay.
It's like another contract.
Is it like a recorder there, taking minutes, all that kind of thing, or no? Okay.
No, I have a little, it's so down and dirty, I have a little piece of paper I write on and everybody signs it, they're
Okay,
stuck.
okay.
Yeah, so if we did reach an agreement, we have that informal that Judge Aceto writes out, or the other mediator, whoever it is. And then the attorneys draft up the formal final agreement. But if they don't sign that, because I've had this happen.
I've had that happen.
Yeah.
If they don't sign that, we still have the agreement. And then if I do have to file the Superior Court action, I can show the judge that at the return hearing, it's game over. It's just fast tracked at that point.
Are the costs of the mediation split, or do they always fall on the
The
HOA?
associations.
What do you see, Judge?
I've seen both ways, but traditionally mediation costs are split, but sometimes the HOA is pulling their hair out, and they just wanna take a shot at getting it done, and they say, we'll pay both ends.
Well, thank you so much, Judge, for coming in and answering some
Yes,
questions.